I got here as quick as I could. When Dad died a few years ago, Mom handled everything. Now she's gone and it's up to us. Does anyone know if there was a particular funeral home that she might have wanted to use?
Well, I don't know, but I know she mentioned to me once that she wanted to be cremated.
Oh, I can't believe that. She wouldn't have wanted that. No, I won't agree to that.
I don't think she would have wanted an open casket or a viewing either. I'm not sure she wanted any service at all. Or at least I think she would have wanted something very small.
Well, we have to have a service. We're going to show people that we loved and respected our mother. She's not going to be buried in a pine box. We'll just have to figure out what would be nice for the family that are flying in and friends here in town.
Did Mom even have a will?
Well, I have a card for an attorney, but when I called that number, the number was disconnected.
Oh, great.
So I guess we're going to have to just search the house and see if we can find the will.
Oh my gosh, there's so much stuff in there.
Well, I think she may have had a will, but I think it's in a safety deposit box. I asked the bank about getting into the box, and they said I would have to get a court order
Oh
no.
to even look in the box.
Can't believe
Can you believe it?
Crazy. That's crazy.
To even see if there's a will.
Well, I hope she had a will because she promised some things to my daughter that I know my daughter would love to have.
Well, I hope they're not the same things she promised to my daughter.
No, ladies, what are we going to do about the house? It's going to need to be cleaned out, and what are we going to do with the furniture?
And what about Daisy? Who is going to take care of her? Maybe we may even have to take her to the pound.
Oh, no, we can't do that.
Well, before anybody even thinks about taking Daisy to the pound, let's see if we can find anything as to what Mom wanted done with her. I don't think she would have wanted Daisy taken to the pound.
No,
Mom loved that
definitely
dog.
not.
That dog was a faithful companion to her, gave Mom someone to love and take care of, and I know that the dog loved her back. Maybe the next door neighbor would take her.
Well, I'll pay for Daisy's food, but we'll have to find someone to take care of her after I leave because I can't take her to Michigan with me. I know that's just not going to happen.
Well, and I can't take her back to Wisconsin either. Maybe the next door neighbor would take care of her until we can find a home for her, if they don't want to take her.
And how are we even going to pay for the funeral?
I don't know. We may just all have to chip in to pay for the funeral until someone can get permission to use some of Mom's money. Lori, I know that your husband has been sick and you haven't had a lot of work lately, so the rest of us will just have to cover things until someone is able to use Mom's money.
And so where are the keys to the house?
I don't know.
And should we have the locks changed?
Can't I use Mom's car while I'm here? I hate to rent a car.
Really?
Don't look at me like that. You know Mom loves me. She would have let me use the car.
Yeah, but you can well afford to rent a
Now,
car.
ladies, just...
Maybe we should contact the insurance agent for the house and the car. We need to find out what's legal. Does anyone know who that is?
I have no idea.
I sure wish we had talked to Mom before she passed away.
Me
about all
too.
this.
This is not going to happen to your family because you are watching this presentation. Our next segment is what to do after your loved one has died. All right, so this segment is, as it said in the vignette, that's what we call them, for lack of a better term, I guess. And as you can tell, we're not professional actresses, but we try to give a sense of what we actually see with families where good planning has not been done, because we do see those from time to time, not in our clients, but there are people that come to us from outside that, and that's what they look like. They're all kind of like, what do we do? So with respect to a trust, what happens after someone is gone, then the process of winding down the affairs begins. And we refer to this as trust settlement. Sometimes you hear it as trust administration. I usually call it settlement because trust administration sounds like it's something that's just sort of going to go on and on and on and on, and we certainly don't want that. Although it does take some time. There is some work that needs to be done. So, things to do. What you will find in the front of your helper's handbook is a laminated card, and it is a checklist of things to do. So, do know where the red and white books are located, and review the final arrangements instructions as well, so that you're not like this family we were depicting going, what do we do, what did mom want? Because if your loved one has filled out the final arrangements instructions, then you have a listing of what they want. So again, helpers, this is where you can be a good advocate and say to your loved one, have you filled that out? If you filled it out, where are you keeping it? And by the way, is there anything you'd like to talk to me about? And with respect to that, we also find that many people will fill out the final arrangements and then use that as kind of a template or a checklist to go to one of the local funeral homes or to otherwise make pre-paid, pre-planning arrangements. And I have cards in my office of the lady that handles the advanced directives for Hatfields and Jensen's here in town. I hand those out freely. She's a wonderful person by the name of Fern McReynolds that I've known for 15 years or so, and is very knowledgeable in this area. Other clients will have something like a whole body donation to the University of Arizona, Neptune Society. There are a number of them out there. Science Care is another one. And I have information on all of those programs available in my office, and I do provide them to clients. But the important thing is to find out, what does your loved one want? And we have the final arrangements instructions for that purpose to be able to provide that information. And do, of course, arrange for the immediate care of pets. So we've been talking about Daisy in the little vignettes that we're doing, who is the dog. And in the past, we've sometimes actually filmed the dog herself and had one of my dogs standing in for Daisy. Do secure the house, change the locks, and call the insurance agent for the auto and the home. Because the insurance changes if the house is not occupied anymore. So, I mean, if it's a married couple where one of the surviving spouse is continuing to occupy the house, it's not as critical. But if the house is not going to be occupied because it's the second person that has passed away or a single person, then if you don't notify the insurance company that the house is not being occupied and there's some kind of like a water line break, they can refuse to cover that because there is a different rating schedule for an unoccupied house than there is for an occupied home. And there's also some issues with the automobile policies as well. Do schedule a settlement conference with the law office. We usually say within 2 weeks. When people call us and say that one of our clients has passed, our response is always take care of your family matters first, and then we will do the settlement conference. And make a list of questions, because people, as I say, are very stressed during this period of time and can't remember things well, and so write them down, and that way we can get your questions answered when you come in. Now, also on this list, this laminated card, is things not to do. So don't race to the bank and close accounts. Don't roll over IRAs, 401ks, and other qualified retirement plans. Oh, and Jean is reminding me that she has extra blank copies of the hypothetical scenarios and the letter of instruction to my healthcare agent for anyone that would like those today, that perhaps wants to make some changes to it, clients, or otherwise would like to have them. Jean has extras of those over at the table, and you can pick them up from her as well. So going back to the things not to do, I touched on the automobile a few minutes ago. If it's a married couple where the surviving spouse is continuing to drive the car, that's fine. But if we have family fly in from around the country and they see a vehicle that is in the driveway and they're thinking, well, why should we rent a car when we can drive that vehicle? That is an absolute no-no, because the insurance stopped when the owner died. And many of the insurance companies will not continue the insurance on the vehicle once the owner has passed away. So if somebody's driving the car, they are very often driving an uninsured vehicle, and thereby, that vehicle is in the trust. It will put all of the assets of the trust at risk for the liability of that vehicle, not only for the person who's driving it, but all the other people who are the beneficiaries of that trust or other beneficiaries. And even if the insurance were to continue after the death of the owner, it's still a really bad idea to be driving that vehicle because it's still putting all of the assets of the trust at risk for the liability of that vehicle. So what we like to do is get that vehicle out of the trust very quickly, either distribute it to someone who wants to take it as part of their share of the estate, or if it's not going to be taken by someone who is a beneficiary, then we would want to go ahead and get it sold. Even if you have a designated driver on the policy often ends when the owner dies. That's the experience of it. And the second problem, as I went on to say, is even if that insurance would continue for that driver, it's still a bad idea for the driver for that person to be driving the vehicle, because it puts the rest of the assets of the trust at risk for the liability that's associated with that car. I mean, if they get into an accident and the limits of liability are not high enough to cover the accident, then the other party is going to be looking to the assets of the trust. So what we want to do instead is get that car out of the trust, because cars are a high liability asset. We don't mind having them in there while people are alive, because having the car outside of a trust does not protect the assets of a trust here in Arizona. Now, that's not true in some other states. There are other states, I think Nevada is one of them, that says if you own a vehicle and it's not in your trust and you have an accident, and if you cause the accident and you meet your demise in that accident, the aggrieved parties cannot reach the assets of the trust. But Arizona has what's called an expanded probate statute that says that if the probate assets are insufficient to satisfy creditors' claims, then creditors can reach other non-probate assets. Well, the assets of the trust are non-probate assets. So while the person is alive, while people are alive and have a vehicle in the trust, it's a good idea, because then we can do something with that vehicle right after the death. Whereas if the vehicle's not in the trust, we have to wait 30 days after the date of death before we can use an affidavit of transfer to do anything with it. And in the meantime, it's just kind of sitting there, and I have to tell people, you can't drive that car, and then they don't like me very much. So I would much rather have it in the trust, because then a successor trustee can do something with it as soon as a death certificate is issued. So it's just, do not drive the decedent's vehicle unless you're a spouse and it's a joint trust. Then, you know, it's not a problem. It's just a problem if it's the second spouse that is now gone or a single person that's gone. Don't drive the vehicle. It's just a bad idea all the way around. Don't start divvying up household furniture and furnishings. There may be a personal property list that says that certain items are supposed to go to certain people. So we need to follow that process, because that will be a document that is in the Big Red Book. Don't pay bills. Ask for a 2 to 4 week extension on funeral expenses. If they won't give it and somebody does pay the funeral expenses, that is an administrative expense that is reimbursed off the top of the assets that are inside of the trust. And for heaven's sakes, don't use the decedent's credit cards, debit cards, unless, again, you're the spouse. If you're the spouse and you're joined on that account, by all means, you can continue to use credit cards and debit cards. But it's fraud to use a decedent's debit cards, credit cards after they have died, so don't do it. And don't contact the life insurance company and annuity companies. We know that financial advisors are sometimes very well-meaning and they want to help, but there are distributions that are set up in many cases for those assets in the trust, and so we want to make sure that those distributions, those instructions in the trust are in fact followed with respect to all of the assets. You know, things like utility bills for the house, yeah, you do want to continue to pay those, but what we find sometimes is that sometimes bills that come in right after someone has passed away are bogus, to put it quite bluntly. And so we want to make sure that there's an orderly process for reviewing them and making sure that they are in fact legitimate. You know, generally utility bills are often paid by automatic withdrawal and automatic onto a credit card anyway, and that's okay. I'm not concerned that SSVEC is sending a bogus bill, but we have seen fraudulent claims being made because, you know, they see a picture in the newspaper, an obituary, and suddenly you got a bill from some plumber nobody heard about. nobody ever heard of before. And so I don't want clients just, paying it sort of as a knee-jerk reaction until we have an opportunity to examine it. So the plumber, by the way, was a real was a real case that happened where somebody had done some work and cut a water pipe and had left a huge mess, and then he sent a bill for it. And when we took a hard look at it, it was like, you don't deserve a penny, buddy. And so we didn't pay him. And don't use powers of attorney either, because the power of attorney terminates as soon as the principal dies. And so those assets that are outside of the trust where the trust may have been named as a beneficiary, there's procedures then for getting those assets to pay into the trust, but you don't use the power of attorney to do that. We're using beneficiary designations. And again, it's fraud to use the power of attorney after the death. And sometimes people will say to me, well, I don't understand. It says it's a durable power of attorney. Well, what that means is that it continues in effect after someone has become disabled. It's not a durable power of attorney in the sense that it continues in effect after someone has died. It used to be, the old rules were that a power of attorney would become invalid as soon as the principal was disabled. Well, that wasn't very useful, so they changed it. And that's what they call a durable power of attorney, that it continues to be valid even after someone becomes disabled. And it says that right in the document itself. But that doesn't mean that it continues in effect after the principal has died. So that's our conference room. Clients, most of them have seen that conference room, but that's where we would have our meeting, is in that conference room. Or a lot of times now, we have families scattered all over the country, and so we're doing teleconferencing. We may be able to use our video teleconferencing equipment with our 8 lines. I've got one scheduled for Monday for which we'll be using GoToMeeting and do a teleconference that way. And we'll let you know if there's any documents that you need to have available for that. Most of the time, not. Do understand that the ethical guidelines under which we operate, that we're required to operate by the State Bar Association in Arizona, require that we meet only with successor trustees and named beneficiaries. So spouses cannot be present during that initial settlement conference. What someone chooses to share with their spouse afterwards is entirely up to them, but the spouses, it's not that we don't like them, it's just that we have to be talking to the people who are the actual interested parties with respect to the administration of the trust estate. So in the settlement conference, we'll be talking about an overview, answering specific questions about how this specific trust works, who are the beneficiaries of the trust. We may talk about possible tax planning strategies that we do tax planning in advance. Like I've got one situation where charitable beneficiaries are going to be the primary beneficiaries of the residue of the trust, so we're actually naming the charitable beneficiaries as the beneficiaries of the tax-deferred assets. Because if we make that distribution prior to September 30th of the year following the year of death, then the charities get to take those tax-deferred assets and cash them in without paying any income tax on them. So I'm not a tax advisor, and I don't hold myself out to be, but I certainly know enough about it in this area to use tax planning strategies prior to someone's death, and we can take a look at them as well after someone is gone. We'll figure out who's going to do what. We'll actually have a list of, okay, who's going to be responsible for changing the locks on the house, for making sure the dog is taken care of, what's the law firm going to do, what are other people that are involved going to be doing. And we'll talk about timetables of what the expectations are in terms of getting things done, and address questions, our fees as well, with respect to the settlement process, and if people are comfortable with going forward with us to assist with the settlement of the trust, then we will have them sign an engagement letter as well. It would be the successor trustees. And I'm always very careful to say to clients as well as to helpers, you're not stuck with us. It's a service, not a noose. So far, I think we have 100% of the successions have decided to use us for settlement, but you're not stuck with us. So within sort of the scope of an estate plan, there's 3 main time periods. People are alive and healthy. The next one, alive and not so healthy. And the next one is what happens after the demise. So let's assume for the minute that we're talking about either the second spouse has passed away now or it's a single person. But whoever it is, we've got this living trust. And then we'll have a period of time during which we're in an administrative trust. And that's when taxes get paid, if there are any taxes to be paid, expenses get paid. That's when houses and things tend to get sold, and assets, personal property assets that may be directed are also distributed. So let me address taxes for a couple of minutes, because one of the questions that I always get is, okay, what's this going to cost my beneficiaries? Well, when it comes to estate or inheritance taxes, Arizona doesn't have any. And it doesn't matter where the beneficiary lives, the estate or inheritance tax is governed by the state of domicile of the decedent, which, if it's Arizona, there is no estate or inheritance tax. For federal estate tax, the exclusion for that is going up as of January 1st of this next year to $5,400,000 per person. So I hear over here, oh wow, it's yeah, most of my clients are like, we don't need to worry about that. We don't have that kind of money. And they're right. They don't need to worry about it. I think I've got 2 clients in my practice where we're over the federal estate tax exclusions for them, because it's only affecting about 0.5% of the population these days. So in the majority of cases, the only taxes that we see in these administrative trusts are going to be the real estate taxes that have to be paid during the period of time that the house is in administration before it's sold or distributed, as the case may be. And once we've gotten the assets marshaled in a form that makes them convenient to transfer out to beneficiaries' trusts, you can see that in 99.9% of the trusts that I've created, we're going to not be distributing assets outright to a beneficiary. We are instead going to be distributing them to a trust for the benefit of the beneficiary. So we want people to be aware of this, because if the first time that beneficiaries learn that they're not going to receive assets outright is after mom or dad is gone, their attitude may be along the lines of, well, what did I ever do to mom and dad that they decided they didn't trust me, and they're not handing the assets to me outright, they're handing them in this stupid trust box that I've got to deal with. Well, there's really a very good reason why mom and dad did that. But before I get there, as part of the administrative trust, we do want to build an inventory, and once again, that inventory is helped by the fact that we've been asking clients or their helpers to continue to keep us updated with regard to their finances, what they own, where it's located, the values and such. We will need to secure valuations as of the date of death of all of the assets. So we might be asking somebody like Phil, provide us with a date of death value on these stock accounts, and that's not as easy as it looks, because there's actually a process for that by which there have to be averages that are taken of the account during the day to pop out with a date of death value, and so we leave that to the professionals like Phil to provide us with that sort of information. For houses, we go ahead and we get appraisals. We'll be assisting with the settlement of life insurance, annuities, figuring out where the qualified plans are going to go, and identify now. Some cases, Paulette is a great negotiator. We had one case where there were some very high hospital bills and there wasn't medical insurance, and she negotiated those down to a considerably lower amount, which then of course means more money going into the pocket of the beneficiary of that particular trust. So identify, negotiate, and then pay the final debts, legitimate final debts and expenses of the decedent. And we also are heavily involved in tracking the income as it comes in, because I want to tell you, I've seen a trust that came in where the income wasn't one of mine, but they didn't track the income as it came in, and trying to reconstruct that is a real mess. So Paulette works very closely with the successor trustees to make sure that income is properly tracked and allocated so that the tax returns that have to be filed for the trust are accurate for that purpose. 3 to 12 months, depends. Lately, houses have been taking longer to sell here in this area, so it can be longer, but we want to set the expectation. This is not going to happen yesterday already. It's going to take a little bit of time, and we'll have periodic meetings, sometimes in person for folks that are here local in this area. More often, we've been working with people across the country. We've got one client we've been settling a trust with that any given day she might be in Qatar. She's in the military and she's in a command position, so wherever she is, we communicate with her by email and teleconference and such. And we're very well wired, we're very used to that. So the successor death trustees are going to be named in Article 15 for married clients, Article 12 for single clients, and they assume complete financial control of the trust assets on the death of the trust maker. And they have to follow the instructions and the priorities that are contained in the trust. They're responsible for managing the assets in the interim before they get distributed out to the beneficiaries. So there's 3 kinds of distributions. One of them is what we call the special stuff list. So in my family, for example, when my grandmother asked me, after my grandfather passed away, what did I want as a memento of my grandfather? And I said, I wanted his pocket watch. It's one of these little railroad watches. I've seen them on eBay for like $5. They don't have any particular monetary value, but my grandfather was of a generation where I remember that he would take that watch out and look at it to see if it was time to go down from his garage, where he was a mechanic, to the house to have lunch. And so every time I look at that pocket watch, which I have in a little glass case, or I tell this story, I remember my grandfather. I remember what he looked like. I remember he always smelled of motor oil. When I smell motor oil, I think of my grandpa, because that was a smell that I associated with him. So we ask people, talk to your families, find out if there are any items that you have that they may want as a memento of you. And it might be that you have some things, for example, that are heirlooms from your family, and it's not your children that are so much interested in them. It may be brothers, sisters, or nieces or nephews. Find out who wants what. And if you find that there's 2 people that want the same thing, isn't it better to settle that possible disagreement while you're here instead of waiting for it to blow up after you're gone? Because we want to pull families together. We don't want families to be blown apart. And studies have shown that disputes are 5 times more likely to erupt over items of tangible personal property than over finances. And so we want to make sure that those sorts of situations don't escalate, because they can affect and impact on people's relationships for the rest of their lives. And we want those relationships to be good relationships, not relationships that are tinged with some kind of resentment. So if there is a special stuff list, it's going to be toward the end of the book. There are also specific distributions that are set forth in Article 7, and there are percentage distributions that will be set forth in Article 9 of a single trust and Article 12 of a joint trust. So what I find is that men tend to want to leave guns, tools, and automobiles, and women are leaving furniture and jewelry. Now, the automobile actually can't be on the special stuff list because it has a title, but the guns and tools, those can be on the special stuff list, and certainly the furniture and jewelry or other items such as that. And as I say, these items typically are those of sentimental value, and the lists, the legal term for it, or the term that you'll see in the book, is the tangible personal property list. Memorandum of tangible personal property. And so it'll say this item goes to this person, this item goes to this person. And we actually distribute the dog that way as well. Who's going to take care of the dog after you're gone is on the special stuff list. And if that person can't do it, then this one, and if none of them can do it, then the trustees to find an appropriate home for the dog. So it's in the Red Book under the tab that is entitled Personal Effects toward the back of the book. And not all clients create a special stuff list, so if you don't find one in there, don't panic. It just means that your loved one didn't do that. Then the automobile can be in Article 7, the schedule of specific distributions. So this can be used for distributing $5,000 to the church, a specific sum of money to the neighbor who's been so kind in helping someone, specific investment accounts, pets, if there's money that is going with the pet for their care, would be found in at the end of Article 7, the specific distributions. And again, not everybody has specific distributions, so if you look in the book at the end of Article 7 and there isn't anything there, and the last sentence of Article 7 says, I don't choose to make any specific distributions, then there just aren't any to be concerned about. The percentage distributions then are all of the other assets that have not been distributed by the special stuff list or the schedule of specific distributions, and those are divided up then among the beneficiaries into a separate trust share in almost all cases for their benefit. So I'm getting to why do we do this? Who knows the school bus story? Come on, clients. Come on, who knows the school bus story? Okay, I see some hands getting raised. All right, here's the story that we use to help beneficiaries and clients understand why we do the type of planning that we do. If someone is driving along on an icy night, which we can get even down here in southeastern Arizona, maybe going a little bit too fast, hits a patch of ice and hits a school bus, I don't care how much car insurance you've got. There is not enough money in the world to adequately compensate for the death or the severe injury of a child. If that happens, and you're a beneficiary, then everything you own could be subjected to a catastrophic judgment creditor's claim. But what we want to do in setting up a trust share is take advantage of a principle of the law that says when someone settles a trust for the benefit of someone else, the assets inside of that trust are protected from the beneficiary's creditors. So now if the beneficiary is driving along and hits that school bus, everything else they own may be subjected to a catastrophic judgment creditor's claim, but the assets inside of that trust share are not. And if the beneficiary should, God forbid, get hit by a school bus and become a special needs person and have to go into some type of long-term care situation, everything else they own may be subjected to a Medicaid spend down, but the assets inside of that trust box will switch into a special needs trust, which is a type of trust where the assets can be used to enhance the quality of a beneficiary's life without disturbing the ability of a beneficiary to receive whatever public benefits they're otherwise entitled to receive. So what we want beneficiaries to understand, that this is the primary reason in my practice that the majority of my clients do trust-based estate planning, because this is a huge gift that they can provide to beneficiaries that beneficiaries cannot do for themselves. Because if the assets are handed outright to the beneficiary and the beneficiary is a smart person and says, well, I think I'll create a revocable living trust and I'll put these assets I got from Dad into my trust, they are sitting in the same boat that my trust makers are when they first come in, which is you can't put your own stuff into your own trust and be your own trustee and retain control of it and protect your own assets from your own creditors. This is a gift that only someone can give to someone else. And it's a gift that husbands and wives actually can give to themselves, because we'll split the trust on the death of the first, and then the decedent's trust is protected for the benefit of the surviving spouse, so we get asset protection at that level for a surviving spouse, and then it becomes even more powerful when the surviving spouse is gone, because now we have asset protection for the beneficiaries. So school bus trusts is what we call them. That's our shorthand way of saying this is a protected trust. And all of my clients understand what I'm talking about when I say this is a school bus trust. It can provide catastrophic illness protection, catastrophic creditor protection, divorce protection, bloodline protection to ensure that assets don't go outside of the family and continue down the bloodline. And it also provides a vehicle for values promotion as well within the instructions that are provided in the trust by the trust makers for their loved ones, which is passing along not just stuff, but a legacy of the trust makers' love, care, and concern for the people who will be the ultimate beneficiaries of these trusts. Now, it only works if two requirements are met. First, that the beneficiary not be the sole trustee. This does not mean that the beneficiary doesn't have control of the trust. But in almost all of the legacy trusts, and that's what we call them, legacy trusts that I've done, there's a requirement that the beneficiary trustee has to have a co-trustee. Now, Arizona has a very strong statute that says that a beneficiary can be the only beneficiary of a trust and the only trustee of their own trust share and still get these creditor protections that I'm talking about. But not all of our beneficiaries live in Arizona. Or if a beneficiary were traveling in another state, there are states that have held that if a person is the only beneficiary of a trust and the only trustee of the trust, then that's not really a trust. Those states have allowed creditors to step into the shoes of beneficiaries and use their position to reach into the trust. So to protect these legacy trusts in all 50 states, we have the requirement that the beneficiary have a co-trustee. And in most cases, they're going to be charged with the responsibility of choosing that co-trustee themselves. So it's also important that the beneficiary be educated as to what actions could destroy the trust protections, and that's part of what we do in the settlement process. Also, after the first of the year, I'm going to be talking to John over here about doing a recording of another piece of my Nuts and Bolts series, which will be Maximizing Your Inheritance, which is specifically targeted toward beneficiaries and talking more expansively about what things to do and what not to do with respect to the administration of one of these legacy trusts. And that will be put up on our client website in the protected area to which the password will gain access. Now, in tab 7 of the Helper's Handbook, then there are, as I said earlier, as I touched on earlier, there are a set of sample trust settlement instructions, and tab 8 has the frequently asked questions that provides a short summary of common questions and answers. We also have a list of resources here in the community, things like cleaning services, hospice care, things like that. The most recent one that we have from the Area Aging Council, or Area on Aging Council, is from 2013. So there isn't a more recent one that they have done. But there are other resources that we know of in the firm as well, so ask us. And because we're here to help beyond the legal issues, we really are. And then we have the glossary of terms, again, that provides the various terms and the acronyms as well. Now, at this point, I'm going to veer off on what's going to appear to be a totally different track, like I just went off toward the moon or something. So bear with me for a while, okay? Just bear with me for a minute. So, do you like horror movies? Yeah, okay. And that doesn't surprise me. My experience is that the older a person is, the less they like them. But I'm not talking about slasher movies. I'm talking about the older movies with actors like Lon Chaney and Bela Lugosi and other classically trained actors. And those movies were more like theater plays than movies are today. So usually with seniors, they're kind of like, well, I'm still not real crazy about them, but you know, they're a little bit more positive. So are you at least familiar with those? Everybody at least familiar with what I'm talking about? Okay. So here's the question that I'm going to ask you. How would you like to star in one of those? Yeah, okay. That's what happens without good planning and education. So here's the deal. Have you noticed that in all the werewolf movies, there's a background where, you know, people are meeting each other and they're going along and you get to know the cast of characters. And there's even some of them where they actually laugh about the rules because the rules are different in movies than they are out here in the rest of the world. So you get to know the main characters, and with the storyline, there's always some kind of a love interest, because you got to have a love interest in order for you to be even interested in this person that you know is going to get bit by a werewolf. So, you know, it has to be shocking that this happens, and it's not going to be very shocking if you don't care about them. So there's always this love interest. So the attack occurs. The werewolf bites the person. So at this point, I find that some of my older clients can practically tell the story for me because it's kind of a formulaic storyline. There's a survivor, because someone's got to survive. And have you noticed that there's always a friend who knows? Now, sometimes it's something like a library book falls off the shelf and it opens up to werewolves, and there's dramatic music that plays to make sure that you know that this is important. And sometimes there's a lady ad, a seance or something, and sometimes they just have a know-it-all friend that just seems to know everything. But there's always a friend who knows everything. And then they have advisors that say, oh, you weren't bitten by a werewolf, the doctors say this or the doctors say that. There's no such thing as werewolves. And then, of course, again, there's still the love interest to make the movie interesting. So that's the cast of characters at that point. So here's my favorite part. How do you kill a werewolf? Come on, anybody? Oh, what do you know? I got the right answer. Sometimes what I get is a stake through the heart. That's vampires. They've always outmarketed the werewolves. And it seems like every time I turn around today, there's vampires on the television and vampires in movies along with the zombies. It seems like they're just sort of all over the place out there these days. So this is a little bit trickier. Who fires the silver bullet? You're right. That's a different movie. In the werewolf movie, the person who fires the silver bullet is the loved one. So it's not just any bullet, and it's not just any person. It's the loved one who fires the silver bullet. So by now you're asking, what in the world does this have to do with estate planning? Well, what it's about is, how do you kill, or more accurately in this context, control werewolf behavior? We don't want you to kill your mother or your father, or maybe it's an adult child, the surviving spouse, but they change in the grieving process. You'll see books that make it look like it's all nice and neat and tidy. There's these stages of anger and bargaining and etc. But everybody goes through it differently. And the important point is, they're not themselves. So we have situations with wonderful, nice ladies, and their reaction to the death of their husband is to, metaphorically at least, grow fangs, sprout hair, they yell at you, they're emotional, they're impatient, all the things that they weren't. It's just how they react to grieving. So they're like the werewolf in this context. So how you control werewolf behavior is through education and setting proper expectations. So your role as a helper is to rally around the process, because the process produces the results that were intended when the plan was created. So without training, what would you normally do? Well, I would support my mother, I would support my father, who's in pain and grieving and complaining about everyone and everything around them. Life isn't fair, this is a terrible time, and on and on and on. So let's take a look at another cast of characters. Now we have a new set of characters. We don't have a victim anymore, they're gone. We have a new character, the survivor. If there was a single person or you're the second parent, you're the survivor. And it does sometimes happen that there's an adult child that is the werewolf, but that's not as shocking to us, because with the nice little lady that we've had a relationship for 9 years and even more, because I have clients that were actually with me in my prior practice that transitioned into this estate planning practice, so I can have 10, 11 years of relationship with them. It is shocking to us when we start seeing this kind of behavior because of the relationship. But they grow out of it, everything passes, but it's really hard during the adjustment period. So who's the friend who knows? Everybody. Everybody else. They're telling the story all around. The neighbor's saying, when my father died, I didn't have to do that. When George died, this is what happened. I don't know why you're doing this. Isn't there something you have to file somewhere or something during some period of time? You'd be amazed at the garbled stuff that we end up getting into our office. Financial advisors sometimes trying to help. I don't know why you need a trust. You avoided probate. Your parents had a living trust. Why do you need a trust now? So they dive in sometimes from the outside. We've summarized all of those into one character that I'm going to introduce to you now. We call her Marge. And wherever it comes from, the outside, we're going to say, who did you talk to? Now, as soon as you get that question, what happens by now, the trained client helpers just kind of stop because they know what's coming. And I'll say, you talked to Marge, right? Marge holds court at Burger King. That's where she goes every morning to get her senior coffee, and she holds court, and she knows everything about everything. So, you know, they're seniors. When they've exhausted all the complaints about the doctors, then they start in on the finances. Well, they're a source of information, as are other non-estate planners. So the CPA knows a portion, the financial advisor knows a portion. What we want is a team where we're all working together. So if you lean on those others in what is our part of the process, you're likely to end up really frustrated. So we just say, Marge told you that, right? And hopefully the response is, you just laugh. And we'll say, what did she say? What did Marge have to say? And they'll tell me she said this or that, and we can provide an answer. But at least you have better humor about it, and you probably know I'm going to contradict it, and so that works pretty well. So we are the friend who knows. We really do know what it is that you need to know. And we know how to survive the attack. What's the attack? That's the death. So there is a friend who knows. Don't go to outside advisors, go to the friend who knows. And so how do you control werewolf behavior? With advanced preparation and proper expectations. So now let's take a look at the cast of characters again. We're the friend that really does know, but we need the loved ones to help the survivor through the grieving process and to help us help the family. So if you're an adult child in particular, the natural inclination is to reinforce mom's behavior. If that happens, sometimes later people come back and they apologize, and there's no need to apologize because we know what's going on. What we need you to do is to gently nudge. Mom, there's a process. That's why you did all this work. Dad, there's a process. That's why you picked this gal or this law firm. Let's just go with the process. You'll do that more effectively if you know what the process is, and that's part of the point of these educational programs. So it's not about the documents. That's like, duh. It's not about the documents. What we find is that there's lots of excitement when we start out with these plans, that there's excitement for the clients, excitement for their families, excitement for their advisors, and then what we call the parking lot rule sets in. Anybody remember the parking lot story? That comes from a client who said, as I was walking out the door, I felt like 90% of what you just told me was falling out of my ear and hitting the parking lot. Okay? So repetition is the key to retention. That's why we continue to do these educational programs. The value of what we do, and therefore our fees, is not based upon documents. They're based upon the counseling that we do and the process that produces the results that people want for themselves during their lifetimes and whoever it is that they love and care about after they're gone. So our goals here today was for you to know the law firm name and the contact information, who to get a hold of. Remember that there is a process and that the process produces the results. So follow it, because it works. We want to give you an idea of the types of issues that you'll be dealing with and encourage your interest in participation in this planning. So this is what we call the Wisdom W. It shows the steps in our process. The wisdom is in the process, and the process produces the results. So we recommend that you attend this presentation or that you watch it again online if that's your preference within 2 to 5 years, because repetition is the key to retention, and there are things that change from time to time. We have other educational programs that are offered throughout the year as well. Please contact us for more information. We will be putting the calendar of events into the client area of our website. And beyond that, thank you very much for coming, but give me a minute. We have one more vignette, and then I will let you loose. I can't believe Mom's gone. It just feels so strange to be sitting here in her dining room, and she's not here.
She should be right there with us.
I know.
I'm so used to having her making coffee cake and coffee for us, especially when you two come in from out of town, and I was expecting to be able to smell that aroma
Yeah, it's just
and
not the
that
same, is it?
coziness, the comfort, you know, and it's not here.
No, I know it. Well, let's take a look at this book. One of these, Lori, isn't one of these yours? And
Yes.
Jean, is this one Mom's?
Yes.
Yeah. Okay. Isn't there something? I did.
Oh, yeah.
It's been a while since I've looked at. Oh, that's right. There's this
This is
card.
from Trustee training, isn't it?
Yeah. Well, you and I watched it on DVDs,
That's
but
right.
they were able to go since they
That's
live here in
right.
town. So
Yeah.
I know Jean is the healthcare agent, so she's had Mom's book. When I looked at this a little earlier, it said that the first thing to do was to call the law firm, and so actually I already did that, and I got an appointment for us that's next week for all of
Right.
us after the funeral. And the contact information was all right in here, so that just made it really easy to be able to do that. They told me that Mom kept her red book with all of her estate planning documents in the den, and I already knew that because Mom had mentioned that to me
Okay.
too. So I've got it here, and we can take a look at that as well.
All right.
The next thing on this card list is to review the final arrangements.
Yeah.
Doesn't Mom have some instructions about what she wanted for her funeral service in there?
Yes, she does, and it's behind tab 6.
Oh, yes, I recognize Mom's
It's
writing.
called
Yep.
her instructions for final arrangements. And I went to the funeral home with her a few months ago too, after she filled this out, and she talked to me about it, and then she signed a contract with the funeral home for what she wanted, and she paid for it, and it's right here in the book. And because I'm her healthcare power of attorney, I'll make sure that all this is done as she wanted.
Oh, I'm really glad that she did that, and I'm really glad that you did that with her, Jean.
Yes, I'm so
that is
glad
such
I'm so
that
glad
is
that
such
that
a relief
happened.
to know that that's been taken care of.
Well,
Yes.
she's done so much for me over the years. It was the least that I could do.
Well, I'm
Help her
just
with
glad that
that.
we don't have to try to figure it out.
Right.
We don't have to figure out what she wanted,
Yes.
how to get it taken care of, or how to pay for it. I'm really glad that that's
Right.
been that's been done.
And I've even talked to the neighbor that Mom made arrangements with
okay.
to take care of Daisy.
And that's good.
They are all set to handle it,
Oh, they're
thank
such
goodness.
nice people.
That's great.
I know Mom left some money for them too in the trust to help take care of Daisy for the rest of her life.
Yes,
I'm
yes.
glad Mom did that too.
That's true. I'm the
not the least
successor.
bit surprised.
No, I'm not either. And I'm the successor trustee of the trust, so I'll make sure that that's taken care of.
Oh, good.
And I'll also I'll be able to take care of the bills once I meet with the lawyer and get the paperwork I need. And I'll change the locks on the house. But can I drive the car?
I thought there was something on that card about that, wasn't there? There's something on there on that?
Oh, I see it.
Yeah.
Don't drive to
Don't
Stephen's
drive.
car.
Don't drive the
Okay.
car. Okay. And it also says don't take anything out of the house,
Right.
and don't pay any bills. So
Oh, okay.
so
I better
we'll-
wait. a
we can
little
just
bit.
wait until after we meet with the lawyer to find out about all of
Right.
those
Okay.
things. Does anyone know where Mom's credit cards are?
I'm sure they're in her wallet still.
You think so? Okay,
Yes,
because it says
probably.
don't use the decedent's credit card, so we should probably find those and at least put them in a safe place until we find out what we're
Right,
supposed
that
to do
makes
with them.
sense.
Yeah.
Okay.
Okay. I think we should all just write down any questions that we
That's a
have.
good
and then
idea.
we
That's a
can
really
bring
good
that list
idea.
to the
Very
attorney
good
I just,
idea.
we meet. I mean, things are just so foggy. I'm afraid I'd walk into the lawyer's office and
Right.
forget everything that I
Yeah,
wanted to ask. So
me
I think
too.
it's a really good idea to
Yeah.
write down the questions. So I'm
Yeah.
glad.
I'm still so upset, so I'm really glad this list is here for us.
Yeah, that is really helpful.
These are all
makes
things
things-
I was wondering about.
Yeah,
Isn't it
sure makes
wonderful?
things a lot easier, doesn't
Yeah,
it?
isn't
Yeah.
it wonderful that Mom made all these plans for us how to
Yes.
take care of things? It was so loving on her part,
Right.
and I'm so glad that her attorney and her team are ready to help us with whatever we need.
Me too.
Yes.
Me too.
Thank you all so much for taking time out of your busy lives. Thank you. Thank you so much. I appreciate that. I love what I do. I love the people that I get to do it with. All of you and my team, thank you so much for allowing me to do so and allowing us to be part of your lives and your families as well. Thank you.